Supreme Court of Appeal President Justice Mandisa Maya has rejected allegations that she's deliberately stalled the finalisation of former President Jacob Zuma's 2 appeals. In the statement, the Office of the Chief Justice also confirmed that Maya has dismissed Zuma's application for reconsideration of the appeal against the High Court judgment. The SCA refused his application to have lead prosecutor Billy Downer removed from his multi-billion rand arms deal corruption case. Zuma had wanted the court to squash the charges against him and declare that Downer had no title to prosecute him. The Office of the Chief Justice says Maya only became involved in the matter on Tuesday last week and not in March, as has been widely reported. To help us understand what this means for the former president's corruption trial, let's welcome legal analyst Mpumelelo Zikalala. Good evening to you, and thank you very much for your time on The Full View. So the corruption trial was postponed until August to make room for this very process to happen. Given this decision to dismiss it, where does that leave Mr. Zuma?
Well, it leaves him with a few options. First option is to go back to the Pietermaritzburg High Court and say, I'm ready for the trial. I'm not going to appeal anymore. Can you please put your first witness in the witness box so that you can be able to deal with the matter once and for all? The second option is to say, I want to go to the Constitutional Court. At the Constitutional Court, I'm going to state 3 things which I think are important. Firstly, I'll remind the court that I have a right in terms of Section 34 in terms of access to court, and that entails me having an ability or being afforded an opportunity to make verbal submissions so that they can be able to hear me. I'm of the view that the 8 justices, which are a minimum requirement in order for them to hear my matter, may come to a different conclusion. Linked to that is my right to a fair trial as per Section 35 of our Constitution, which then allows me to go to court and ventilate all those issues in which I'm talking about. The very issue that I have a complaint about is with regards to the prosecutor in this matter was Advocate Billy Downer, who I think by his conduct should or ought to have lost his title to prosecute, because he has engaged in activities in which, in the former president's view, are unbecoming of a prosecutor. Now, with that one, Section 167 of the Constitution would compel the High Court, the Constitutional Court, to listen to the arguments of the former president in terms of saying, let's hear what you've got to say. Are the current preventative measures of prosecutors acting within the course and scope of their employment, acting within the course and scope of the NPA Act, including the Legal Practice Act, have they been complied with? In instances where that has not occurred, what sort of avenues are available to litigants or accused in this matter so that they're able to get redress? The most important point being, remember the Section 35 rights, which are the protection of all the accused, so that at the end of the day, justice is seen to be done in all spheres of our courts.
So, obviously, as to scenario 1, and my question would have been, what would happen to the trial itself? Well, then it would go ahead as planned. But in terms of the other 2 options, what impediment could that place for this particular trial that's now been set down?
It will depend on the timelines which will be attached by the former president's team, because they would have some time from today up until the last day to file this particular appeal. But that will still be within, I think, June and July. So the 1st of August and the 15th of August deadlines will be met. Now the ball would be in the Constitutional Court's hands or court in terms of saying how fast or how expedient can you deal with this matter before the 1st or the 15th of August. Either you are going to dismiss it if you feel that it does not have any merits or there are no prospects of success. Either you say to the former president, come, we want to listen to you. And I don't think they'll be able to do that within this particular 2 months. So we may have see a scenario where the 15th of August deadline will not be met. However, a date immediately after the 15th of August is a date that can be attainable if the former president is not successful at the court.
Okay, so that leads me to this question, which is, as others have written, the delays in this corruption case actually going ahead are the stuff of legend. By my calculation, and notwithstanding some of the changes that happened at the very beginning of this journey, I think it's been about 17 years since he was first charged. As an expert in law, and as far as the concept of justice is concerned, what are the prospects for this case seen from both sides?
That's a very important question, and I always emphasize this point. You see, the quality and the quantity of the evidence is very important because it's going to help you prove your innocence, or it's going to be the one which is going to make or be able to prove to the court that you are guilty beyond reasonable doubt. The memories or the memory capacity of the witnesses is very important. The evidentiary material and the safekeeping of that evidentiary material is very important. It is also super important for the state because they have to prove that you are guilty beyond reasonable doubt, meaning there must be no other explanation other than that which has been presented by the prosecutor that you indeed engaged in this type of conduct. So it is beneficial for both parties to ensure that they're able to start and end the matter within the shortest amount of time so that we're able to harvest the information which we need from the witnesses while it is still fresh, and there are less chances of contradictions, which can work both ways. It can either assist the former president who's accused in this matter or be detrimental in terms of making sure that the quality of the evidence that comes in from the witnesses, they'll be able to remember the finer details. And the chances of those evidence being improbable is probably limited. So it's absolutely important that they're able to deal with this matter as soon as possible. But the former president will then come back and say, I do understand that particular point, but it's also important that I be tried in a just and proper manner. And if it means that I have to traverse all the courts in the protection of my rights, which are available as per the Constitution or as per the Criminal Procedure Act, then so be, so that at the end of the day, I can see that even if I'm found guilty, the process and the method that was used is one which is just and is one which is compliant with all the principles and provisions as tabled in our Constitution.
Yeah, and that's going to be an interesting one to watch, especially if, as you say, you know, the likelihood of delays are there if the former president chooses route 2 or 3, as you described in the beginning of our interview. But thank you very much for your time, Mpumelelo. We really do appreciate your analysis.